And okay, now I'm really hitting it. And we're live. It is Monday, August 1st, 2022. It is 5:01 p.m. Eastern Time, 4:01 p.m. Central Time. Wait, are you really in Central Time?
Alabama, it's Central Time down here.
Oh, yeah. So weird. Okay, so because you were at the SEALS conference, which is the Southeast American Law Schools Association of Law School. What? Shut this. Sorry, Scott. Is it association? Is it what, Academy of Law School? I don't know. What is it?
Southeastern Association of Law Schools.
Right. Okay. So
yeah.
Right. That's
so each part of the country has its own association of law schools. Like there's a Northeast, there's a Southwest, there's a Southeast, there's a Northwest. Is that?
I don't think so. I think just one.
It's just the Southeast as their own conference. You've never heard of this? It's like a whole. Oh yeah, it's really crazy.
No, I've not heard of it.
It's at this giant hotel in Florida. It's always in August. It is like a very expensive hotel. They don't pay for you to go there, but invite you to do panels, and then you go. If you're a glutton for punishment, you go to the Panhandle of Florida for like your summer vacation, and pay for it. So yeah.
Wait, so I'm sorry. I know this is like the least interesting topic, but
we haven't even introduced Will yet. I somehow completely skipped over that. Okay, we'll do that.
Okay, but seriously, like, it's like, why are you teach at the University of Michigan? Is this correct?
That is correct.
Yeah.
And yeah. I have also taught at the University of Michigan, and I do remember that it is not in the southeastern part of the country.
You're not wrong. I don't quite know how I landed here. No, I do know why I landed. My co-author, who couldn't be here today, is one of the
teachers at Iowa.
He teaches at Iowa. Yeah. Which is also not in the southeast.
No, totally right. But God, we agreed to put together a panel for all the southeastern people. So there you go.
Anyways, we are not allowed to have fun anymore. We're not allowed to have our own regional law school conference. But we are.
No, I know. I wasn't pissed off until now. Now I'm like, why the? I feel homeless. I feel.
But we are allowed to have Will Thomas, who I have known in many different ways for a very long time, and kind of one of those magical, like, someone early in your life, and then you think that, like, you kind of part ways, you move to different parts of the country, one of you gets married, and, like, you just think you only work together for a couple of months, you're not going to, like, you have liked that person a lot, but you're never going to see them again. And then it turns out that you become one of your best friends in law school is his best friend. And then you end up hanging out all the time, and all of a sudden you're at that guy's wedding, and you're almost done with your clerkship, and you have no idea what to do with yourself. And you say, I really just don't think I want to go into big law. I think I'm interested in academia, but I don't know. I don't want to go back for a PhD program that's 7 years long. And Will Thomas says to you, I've heard about this new PhD program at Yale Law School. And the rest is history, folks. That's how I met Scott. It started off knowing Will, working at Talking Points Memo. And then we ended up being on the market, curiously enough, I think around like the same time. Well,
yeah, give or take.
Yeah, like a year or two. Yeah. But Will teaches business law at the Ross School of Business at Michigan. He is a scholar of law and philosophy, just like Scott, and just like Scott Hershowitz, who is Will's mentor and neighbor. And hey, welcome to the show, our weird little show.
Thank you. That was good. Also, like, to everybody here, you're welcome, because I put in the least amount of effort to get somebody to become an academic. I just saw Kate at a wedding and said, you should apply to this PhD program. And then she emailed me like 9 months later and said, hey, I'm getting a PhD at Yale right now. And then suddenly he's a law professor.
I mean,
Wow.
it wasn't quite, it was like there was a year that I kind of auditioned for it by going to being the resident fellow at the ISP with Jack. But yes, that's kind of the story. But like, I would never have, like, all of it wouldn't have come on my radar. And it was just, one of those things. So this is why when people ask you how you're doing, you should be very honest and just tell them exactly. Just give it up to the universe and just be like, maybe they will solve this problem for me.
It is true that anytime you have a problem and someone says, "Hey, what's up?" you should just tell them that problem. Yeah, right, exactly. Like, what's up? Like, I just had a terrible fight with my wife or something, and then people love that when you do that.
Yeah. Yes, exactly.
Yeah.
Anyway, so well, we were gonna come on with your co-author, who is also a student of Scott's, but he can't make it. And so you were presenting your essay on your own. Let me grab it. You sent me the abstract, but is it an SSRN?
So that one's not an SSRN. I sent you the sort of precursor piece that is.
Okay.
Yeah.
Cool.
So.
Well, then why don't you kind of explain like the title of the piece and what it's about, and and kind of what you're arguing for.
Yeah, absolutely. So the title of the piece that we're working on right now is called Branding Corporate Criminals. And I can just step back and give a little context for what's going on here. So Mihalis and I are, again, we're both philosophers as well as lawyers. We also both work specifically on issues of corporate crime. And so we agreed to do a symposium sometime last year. And the topic was, in essence, imagine for us symposium participants what the world would look like if corporate criminal law were suddenly abolished and went away. So we spent time trying to figure out what to write. And eventually, we've both been writing in this space for a while, and we kind of just landed on the view that absolutely nothing would change, because although technically we do have a thing called corporate criminal law, it doesn't look anything like criminal law. It is under-enforced, under-theorized, and really just calls for sort of a deep revisiting. So that was that piece. And then we decided that once we wrote the piece, just saying, here's all the problems we see in the current practice, we owed it to sort of step back and try and come up with some better solutions. So
two really quick foundational things. When you say corporate criminal law, what is the level? Who is being punished in that scenario?
No, it's a great question. So black letter doctrine since 1909, at least in the United States, a corporation separate from any of its employees, managers, etc., can be convicted of virtually any crime. Now, almost immediately, right, that gets you into all of these thorny sort of normative conceptual questions. So when you ask me who gets punished, the immediate answer is, oh, you punish the corporation. But like what that means in practice is a really messy thing. So for a long time, the way we approach this problem is to say, if there's a crime committed by an organization, and I can talk about like when we think that happens, we're gonna fine them, right? We're gonna impose a monetary sanction. And one nice thing about monetary sanctions is, look, money is kind of it's the language and lifeblood of business. So it's sort of a fitting punishment. It's not really complicated to figure out what it is to say a corporation owes money. They owe money all the time. So we have this kind of quasi-criminal practice with basically sort of like a fining sanction slapped on top of it. Mm-hmm. Now, there's lots of reasons why that particular approach is not a great sort of solution as a matter of criminal law, but it gets us exactly to this question of what would it mean to punish a corporation? Particularly this corporation at the end of the day is just a lot of individuals, including a lot of individuals who maybe left the corporation. So that's really like where we jump into this. Yeah.
Okay. Before you go, Kate, can we talk about what happened in 1909 that like all of a sudden what motivated American law to adopt corporate criminal liability, which seems such a strange thing.
Yeah, and first off, you're exactly right. My first paper was just trying to figure out why exactly did these doctrines come about. So I can tell you that there's a sort of standard economic story about why this happens, and I think that there's another version of that that's a little bit more true to what judges were up to. The standard story is this. Look, it seems weird to invent criminal law for corporations because for a long time, people thought it was just impossible for a corporation to commit a crime. On the other hand, if you flash back to turn of the 20th century, when we are starting to get into a phase of a real modern regulatory state.
Wait, just really quick. It was
Mm-hmm.
impossible for the corporation to commit the crime because like the actus reus and the mens reus like couldn't be there. Like you couldn't have the intention, and like a corporation couldn't act in kind of like a cohesive way as like an entity. Like just really quick.
So
yeah.
No, it's great. So the line that you get from judges, and this goes back goes back to the 1400s, is a story that goes like this. Look, a corporation doesn't have a body, therefore it can't act. And it doesn't have a mind, therefore it can't intend. So how could it intend to do something bad?
Right.
It's a nice little like syllogistic story about the nature of personality. And it turns out that this is the story. Like this story lasts for a shockingly long time. It starts to break down. And one of the reasons it starts to break down is because corporations go from a relatively novel sort of type of business arrangement to a really prevalent one. So we are so drowned in corporations right now that it's hard to appreciate that at the founding, there was probably something in the order of 250 to 400 corporations nationwide. And all of those were tiny little organizations, right? They ran a turnpike or a toll bridge. They were basically just public utilities, except they had been privatized because the state couldn't afford to start the utility on its own. Banks too was sort of the other one. So at that time, this is how you made a corporation. You would go to your state legislature, petition them for the right to form a corporation, and they would draft you a bespoke charter on the spot. And then they would pass it as a matter of like a legislative act. So every single corporation.
Could, like, sell bespoke charters in Brooklyn, like for like it's just like there'd be like a market for them and some craft beer, like just like.
And the thing is that these charters were legislative acts, right? The granting of charters.
That's
right?
Exactly
so, right. So it wasn't like you wrote to the Secretary of State of whatever, say New York, to do it. You actually had to like petition. You had to petition the legislature, or they created a bunch and then they got sold off or something like that.
That's exactly right. So you had to petition the legislature directly. The stuff we think about as standard features of corporate law now, things like, oh, you could just sell that enterprise to somebody else, or even basic things like limited liability, or the ability of one corporation to buy shares in another corporation. None of that stuff is on the table yet. There is some version of limited liability, but it's nothing like ours. You knew all the shareholders, right? They were really tightly controlled little things. So the way I would describe it is these little like bespoke charters, they're not the same as monopolies, but they're close cousins. And so that's one of the things that happens, right? You get this sort of Jacksonian wave in the United States. People resist this kind of practice. We switch to a world where anybody can start a corporation if they want to, which means suddenly there's lots of corporations, and it turns out those corporations start hurting people and committing torts and eventually things that look criminal. And that old tradition of saying the corporation doesn't have a body or a mind just increasingly becomes like an implausible description of the moral universe that we're in. So I would tell you 1909 is the sort of official start of the federal doctrine, but realistically 1909 is kind of the end of the beginning of the development of corporate criminal law, because the states have been grappling with this for decades and we're in the same direction.
Got it. So yeah, go ahead, Scott.
Yeah. No, I was just going to ask, just for you to put your cards on the table. Do you think it makes sense to hold a corporation liable for a criminal act?
I do. Yeah. So
okay.
I'm writing from a world where I'm committed, in principle, to the idea that it's good to hold corporations criminally responsible.
I see. And so it's not just possible to hold them responsible, but it's good, right, to hold them responsible. despite the fact that you had just said that you wrote this paper saying that it didn't matter.
Oh, right. So I think it would be a good idea to have corporate criminal law. Now,
I see.
it also
I
turns
see.
out that we do.
Okay. I'm sorry. Go ahead. So why don't you develop this idea for us? Thank you.
Yeah. So the thought is we have a thing on the books that purports to be corporate criminal law. And when Mihalis and I look at this, we say, all right, well, let's try and figure out what are some essential features of a criminal justice system. Do we see, not all of them, even just any of them, do we see them there? Is this a system with harsher sanctions? Is this an institution that targets the worst offenders for the worst offenses? Is this stigmatic or condemnatory in the way a criminal justice system works? Does it have sort of specialized procedures, right? Heightened standards of proof, evidentiary rules, those kinds of things. And our answer across the board is it really doesn't. That although we purport to have a corporate criminal law, none of the features of a criminal justice system are present in any meaningful sense in the doctrine that is practiced, or the area that is practiced today. So
interesting.
So that gets to one.
Did you analyze it? Did you analyze
Yeah.
it from an elemental standpoint of like what it takes to have a criminal law, or is this all kind of consequentialist and like it, like, you know, what punishment you end up getting, and like I don't know, like there seems something distinctly like the idea, like in my as a lay person who has poorly formulated this, like that criminal law is so defined as not just defined, because that could also be tort law, but that there has been some type of explicit law that you have like affirmatively broken, and it usually, depending on the severity, the consequences, like you lose your liberty, like you are, right? So like that doesn't seem very like what would that entail as a corporation? It would have to be like you stop doing business, like your assets are seized, like all of these things. So
yeah, okay, cool. So two things in there. Like one is, how do you go about proving the negative, right? If I'm telling you that notwithstanding protestations to the contrary, we don't actually have a system of corporate criminal law, right? Like how do you sort of prove out all the possible contenders? And we're fully candid about the fact that although we can't prove a negative here, we try to be relatively ecumenical. So look, let's just take some basic things that people take to be essential to a criminal law, and let's look at each of them. And even if you're not committed to all of them, presumably you think one of them is important. So you're pointing to one here when you talk about taking away liberty, right? What you might think that is okay, a thing that criminal law sort of purports to do is it purports to punish people for some kind of particularly bad, egregious behavior, something that goes past mere sort of civil or tortious misconduct and rises to some further level. And in part because it's so bad and because we have higher protections, in those circumstances, we are willing to impose sanctions that no other part of the law is supposed to impose, like imprisonment, like execution. Now, if you want to, I said there's two things. The other thing you might pull out is you want to ask yourself, okay, so how tightly do we want to commit ourselves to the analogy between corporate persons and natural persons? So a natural move is to think, okay, natural persons go to prison. That's a really big portion of our criminal justice system. Does that exist over in the corporate space? Now, at least as a sort of analogical matter, the execution thing is actually easier, right? Yes, you can just put the organization out of business. And that actually is possible. There is a provision in the sentencing guidelines that allows that as a sanction. It has been used, we go back and forth in this. I think right now we've found 3 cases of it ever happening, but it is technically possible. The imprisonment, I think, is a substantially harder case. On the other hand, if you think imprisonment is about incapacitating or trying to impose affirmative restraints on the organization, I think you can get a little bit more creative and find a variety of different tools. And where we come to the table, particularly for this upcoming project, is to say, well, look, one way in which corporations are really different from individuals is they are acutely sensitive to public and reputational harms. And also, they lack some of the underlying normative features of individuals that make us squeamish about impacting somebody's reputational harms. So there's things that we could do to a corporation as a form of sanction that we could also do to a human, but we don't want to do to humans that have, for reasons that have nothing to do with punishment.
Because that would be cancel culture. That's why we don't do it.
There you go. Right.
Yeah,
So,
I was going to say, like, because we believe in the dignity of people, like I was from the EU or something all of a sudden. But like, no,
No.
we're
American jurisprudence is very much against cancel culture and against its revival by the radical left. But we do not want to do to corporations what we won't do to people, or what this the reputational harm thing. So if I understand the dialectic here, one of it is like, you can't punish a corporation because you can't put it in jail, or you can't do these other things. Well, actually, you can do a lot of bad things to corporations. One of the things you can do bad to corporations is you can harm their reputation. But like, actually harming somebody's reputation for individuals is normally considered to be what is a bad thing. Is that what you're like? And so, I mean, I'm not sure I fully understood the dialectic here.
Yeah, no, good. So here's what I'd say. There's a variety of different kinds of sanctions that we have imposed over the years. So the use of the term branding is, it's intentionally suggestive here. There's lots of sanctions throughout the history of criminal law that are fundamentally a kind of reputational sanction. Now, if you look at historical examples, right, things like branding, things like the stocks, the pillory, those are also corporal punishment, right? So there's like a physical component to that we have very sensibly decided this is not a thing we should be involved in. In the sort of modern criminal justice movement, there's been a big question about, okay, well, if you could get rid of the corporal part, is there something valuable about having reputational or shaming sanctions in the criminal law? So you've seen examples of this from judges that kind of get mashed together, right? It's the judge who requires somebody to wear a sign or attach a DUI sticker to their car or something like that. So that's a space in criminal law. It's a contentious space. Some people think these are good sanctions because that's better than prison. Other people think, no, that's a kind of sanction we shouldn't engage in for reasons of political philosophy. What we want to do is to say, those kinds of sanctions are both particularly fitting when it comes to the corporation, in part because since it doesn't have a body, one of the things that it prizes the most is its reputation. And to the extent you're squeamish about those kinds of sanctions with respect to criminal law generally, the grounds for your squeamishness are almost certainly not going to attach when it comes to a corporate person instead of a natural one. So it's simultaneously both the case that there's a better case for doing this for corporations, and the objections for doing it to humans aren't really going to attach in any meaningful way.
I see. So the point is that so obviously shaming has been a very big part of punishment practice forever, but it just so happens that you can apply that to corporations, and the lucky thing is that the thing that we find uncomfortable when we apply it to human beings doesn't make us feel the same way about corporations. Is that the way it goes?
I think that's perfect. Yeah.
Okay. Excellent. So, I'm sorry. So, the reason why you think that corporate criminal liability has not helped is because it, to use the old expression, hasn't really even been tried. Is that the?
Yeah, I think we have sort of two kinds of concerns. One is a practical concern that the way the doctrine is carried out around here it hasn't been attended robustly. It has been carried through in meaningful ways. We're not the first to come to that view, right? There's been a long-standing complaint about concerns about under-enforcement, about the challenges of enforcing this, even if you wanted to, about the fact that you kind of have to do some, cooperating with the entity you're investigating, which gets you into dodgy territory. So lots of practical concerns. At the same time, I think we have some sort of fundamental concerns where we think, for example, even if enforcement were improved, even if these practices were carried out, we think that something like a monetary fine is ill-equipped to do what we would like a criminal sanction to do. even a well-executed fine, some of those have to do with the features of corporations and the fact that you can only deter them so far before they get to go bankrupt. Another way to look at the imprisonment point, Kate, is to say, look, we could fine everybody, and if you can't pay the fine, there's this fallback prison, right? You see this kind of line comes from Posner way back when he was looking at Baikal sanctions. If there's no fallback sanction for the corporation, right, if there is no imprisonment, then all you have is the fine. Well, if the company's worth $1 billion and the fine is $10 billion, ratcheting it up to $100 billion, it's all meaningless, right? Because the organization is just going to fold. So fines have a certain cap in terms of their deterrent effectiveness. And at the same time, fines have a really long-standing ambiguous relationship with criminal justice. For most people, I think fines are understood not to be a type of sanction. They are like an alternative to being sanctioned. And it's literally a way to buy yourself out of the real punishment. And so if you want to say, well, the important thing about sanctioning this organization is that we find it, I think actually fines often work to a detriment to the sort of impetus that you get from criminal condemnation.
Well, go ahead, Scott.
I was just going to say, so what do you suggest? So you can't imprison them. You want to hurt their reputation, but you can't do it through fines. So how would you do it?
Yeah, so this is perfect, right? Like when I said we wrote the critical piece and now we're trying to own up to the positive contribution, this is where we're headed. So
okay.
Yeah, no, that's great. So I think we want to offer two things in this paper. One is a substantive contribution and one is a methodological contribution. So I'll punt on the substantive for a minute and come back to it, because the methodological one is honestly taking advantage of the fact that I find myself in a business school. And as I go back through and think about reputation, I realize how little I understand this and how much all of my colleagues who have committed their career to brand management and marketing scholarship have a really deep, acute sense of what's going on in this space. So one of the things we just want to bring to the table is both engaging some of the literature in marketing and brand management, but also just suggesting that one thing that the government ought to take seriously is the fact that if it turns out that prosecutors and judges are bad at thinking about ways to brand corporations or impact their reputation, maybe what they should be doing instead is looking to the people who stake their careers on this and bringing them in to sort of engage in that practice. So we're trying to sort of start a bit of a dialogue between the long-standing existing marketing and management scholarship and the criminal corporate punishment world.
So here are two things from the shame literature that I would say are also better met by your corporate application than from a person, than from, like, let's put it this way, that actually having the state mete out some type of reputational punishment would actually counter one of the harms that is seen in kind of people shaming individuals at like an individual level, or a societal level rather than through like an institution, is that like when you put someone, I have to credit this analogy to Jack Balkin from like way back in the day, but like when you put someone in jail, like there's no need to like continue to pile on. Like they are like reputationally, like they have been like named, they are there is proportionality that attaches to like the nature of the crime. Like you will have your like period in which there is like an asterisk on your name, except if you're Pete Rose, and then it just goes on forever. But that basically like that you can do this and then like it will end. Like there will be a point at which they will take the Scarlet A off of you and you can go, and like, of course, people still remember, but the idea that there has been some type of actual procedural justice and not just a mob shaming kind of normative justice means that there is some closure for society, means that the shame doesn't have to be interminable and go forever, and the shaming doesn't have to go forever. And so that's also, I would say, like much better handled if you're going to mete out shame, to have it done in that type of way adds a lot of kind of like limits about a lot of the normative punishment that we don't like.
Yeah, okay, good. So this is So there's a view I encounter when I look at the shame literature, and I think you're sort of getting to this space where some people don't like shaming sanctions, and fundamentally what they're really concerned about is we just don't think that shame is the kind of thing that ought to occupy space in criminal justice.
Cancel culture.
The experience of being sanctioned is shameful. We understand that, but like if the goal is to do this, here's one way to think about it. Shame is often described as reflective of one's character, propensity. Right? It's a moral emotion about who you are more than what you did wrong. Right? So if criminal law is supposed to be, as Kate described it, time-bound, limited, and we want our sentences to end. Right? You need to, once you are convicted and you have served your sanction, you want that to be over. One thing I would just point out.
This is the problem with cancel culture. It goes on forever. You're canceled forever.
It goes on forever, and we should just understand, right? That like the one of the first and most long-standing forms of cancel culture is criminal epithets. I mean, just think about the number of the language we have to describe people who've been convicted of a crime, right? Murderer, thief, rapist, tax cheat. All of these things collapse the fact of conviction for an individual into their long-standing, enduring status. So I'm open to this idea that we ought to be able to limit these things. I also think that it's just dramatically inconsistent with even just the basic vocabulary we have for thinking about this space, which ironically, we don't actually talk about corporate criminals in that way. We actually do talk about corporate criminals as in a very time-bound, limited way. This company committed a felony back then and it lasted 3 years and that time is over now. So Mihalis is fond of doing this to people, just asking you, like, tell me 5 companies you know that have received a conviction, that you know for a fact that company received one. Remarkably hard to do. And at the same time, I can tell you how to answer this question. Just guess companies you know. Because like, odds are you're going to get some.
Oh, man.
So the sort of stigmatic and shaming vocabulary that occupies criminal justice generally, that I think makes the Balkan story hard, is ironically almost entirely absent from corporate criminal law. Corporate criminal law is very sanitized. It's really this sort of clerical administrative practice. What's especially weird about that is the fact that if we're worried about character propensity, like long-standing demonstrations, how do you know the corporation is responsible? How do you know an organization is responsible instead of some individuals? We look to character, to propensity, to some kind of long, pervasive misconduct here. So I actually think the shame story, not even just like the sanctions, I just think like the idea of sort of shame as a something factoring into criminal justice makes a lot of sense when we talk about corporate criminals in a way that it doesn't make sense with other individuals. So cancel culture is nothing new. It's like the stock and trade of criminal justice.
Right. So cancel culture for corporations, but not for people. Yeah, okay.
I would actually be very happy with that setup.
Okay.
I will say that there like strikes me here as something that's like kind of happens a lot when you have no real like the threat is only to like, so I'm like thinking of examples of like when people are forbidden to like renovate on their house because of zoning regulations. And they could go and ask for a variance, right? But they don't ask for a variance. They just go and build the addition onto their house, and then they ask forgiveness. And they really hope that what they're not going to, like, that basically what they're going to do is punishment for their transgression over like the zoning rules is that they're going to have to pay a fine. So they build this into the cost of building the addition onto their house, is that they'll have to pay a fine. No one expects that they're going to take it out in equity and literally, like, although they do this sometimes, like bulldoze or knock down like the addition that you built onto your house. And in some cases, like raising a house, like you can't put it back up. Like there, if you just go ahead and do that and that violates zoning rules, like then like boo-hoo, like all you can do is fine someone. And so this actually there's a part of this that makes it like, how is this just not all about money at the end of the day? I guess is a little bit like what I'm seeing some of this translating into.
Yeah. So I think I have a couple of reactions. One is just, this is my intuitive hang up, not that I'm deeply antagonistic to a sort of law and econ consequentialist story. As one of my advisors put it, I'm I'm a retributist, which means I care a lot about consequences. It's just I don't care only about consequences. So I think it's absolutely the case that I can redescribe any kind of corporate activity in terms of money, and I just don't think that I can redescribe lots of things in terms of underlying fundamental particles and principles, but that doesn't necessarily obviate the need for higher level descriptions. We could have this conversation purely in the context of sort of electrons or information parsing past the screens, but like it doesn't change the fact that Shapiro keeps yelling cancel culture, and like, right? The fact that there's a lower level description doesn't make the upper go away.
I'm not yelling cancel culture. I'm pointing it out. And I'm sorry, Will, if you can't handle this, but on the show we talk truth to power.
Where is the power?
Yeah.
What?
Wait. What? It's what?
No.
Go ahead.
Yeah.
Go ahead,
so,
Scott.
So yes.
Scott is the power.
So I think your economic story is totally plausible. I also think, right, this kind of question about what's the difference between a penalty and a punishment, right? If you think about the sort of Joel Feinberg view about the expressive function of punishment, the thought is, look, there's lots of things that could be redescribed as not a punishment, right? They could just be something we priced in and built. And in principle, what's supposed to be driving this is the fact that certain kinds of behaviors, certain kinds of things the state does, have been conventionally demarcated as expressing our broader condemnation, right? What makes a monetary sanction different in one context versus the other isn't the fact that like one is higher or lower, it's that one is tied to a social institution that demonstrates we are out there to say what you've done here is bad. Now, this actually does get to one of the reasons why I think our current criminal justice system doesn't work very well. I don't think that the government has done a great job of either building or maintaining any kind of social convention that looks like that. So I think you're exactly right to say if I heard that a corporation was punished with a monetary fine or it paid a monetary fine to some civil regulatory agency, if you did not feel any difference between the two, I think like you're feeling it correctly, right? We don't have a deep sort of social convention embedded in this space. There's a lot of ways to think about how to sort of address that problem, but as to whether or not it's there, like absolutely it's
there. Go ahead, Scott. I'm going to start bringing in guests.
Okay, can I just say something? But based on your extensive study of corporate moral responsibility, we are supposed to hate Facebook and Meta, right?
I am surprised how little
I'm so hurt
liability
that you
there's been
asked
for.
Will this question and not me, Scott.
well, the thing is, you know facts, but Will knows concepts,
Yes,
and so that's a difference. So I'm asking, Will, should we apply the concept of hatred to Meta, or is that inappropriate?
Yeah. So okay, good. So to what extent should we abstain from the kinds of moral emotions we have when it comes to artificial persons? My inclination goes in two directions. One is this is facts, not concepts, but I think it's relevant. The literature in cognitive science and folk psychology suggests both that people fairly reliably engage in this kind of discourse towards organizations, and do so using the same neural pathways that they do for individuals. Now, look, the fact that people do that doesn't necessarily mean it's a reason to do it. On the other hand, I'd put myself in the sort of, I'd put myself in like the Strawson world here, which is to say, I actually don't even know how I would manage life in society if I weren't able to talk about groups as individuals or as single entities. And at some point, if you explained to me that I'm mistaken here, I think I would just tell you, like, you don't get what it is that we do around here, like as a normative community. So
I on that's what makes it so philosophically interesting. On the one hand, we feel very strongly drawn to make evaluative appraisals of collective entities. On the other hand, it's hard to exactly understand what it is that we're doing. But I totally agree with you. It's like that that old line from the Big Chill, where Jeff Goldblum says rationalizations are better than sex, because have you ever gone a whole day without a rationalization? And I feel like, have you gone a full day without blaming some group or something like that? Like, no, you have not. Like you're kind of you at least have the Volk on your side on this.
That's worth a lot. That's good.
Not to overcomplicate this outside the realm of like, but like to Scott's point, like strongly related to what you kind of said about like what people like having intrinsic reactions about an entity or whatever. And Josh Knobe's work on this and the Knobe effect, which is essentially like, this is kind of where actually what Scott just said about blame is so interesting, which is like how much of punishment is about blame. Yeah, Scott, it's your fault. And so like, but seriously, like how much is it there seems, so I wrote a piece about the cognitive science, and I guess it was like technically about the philosophy around this in 2018 after the German wings crash. I don't know if you remember this, but this was like the individual who flew the airplane. Like there was never anything, like no signals went up. He flew it into a mountain, the German like pilot, and they never found out, like he killed all the people on board, and they never found out, like there was no note, there was no evidence of like psychological like issues, there was no like nothing went technically wrong with the plane. It was just like really clear that this guy just committed suicide, and there was like just chose to do this, and like there was nothing to do. And for like the news cycle, for at least this is how I remember it, for like 10 days was just like churning through, and like every single day it was like, well, like he had asked for permission to see a psychologist and his insurance denied him. So it's his insurance company's fault. And then it was like, oh, and like, he hadn't talked to his mother in 4 weeks. So it's like his mother's fault. And then it's like all like, there was just kind of like this. And then eventually it settled on like, well, there just should have been stronger safety provisions in place. That like it was the job of the regulators and the airline. And it's just like, and I talked this through with Bertram Molley, who's a cognitive scientist who studied this kind of stuff. And like, generally speaking, if there isn't a very obvious causal like layer, that we just like trend towards the least cost provider, and like and where those like least cost provider and the one in which like we think has the most power to make any type, even it's performative, but any type of change that gives us basically a feeling that this won't happen to us, or like a feeling that we can like head it off. And so anyways, I just think that that's kind of a very interesting like kind of through line of like Josh's work, what you're describing, and like everything else about kind of blame and punishment.
Yeah. So if I had to give you like the sort of the thorniest like normative and conceptual challenges to corporate criminal law, I would tell you figuring out how to punish an organization, particularly when it might spill down to individuals, is one of them. And I would tell you the other big one is just trying to figure out when is it appropriate to hold the organization responsible for this. In part because on the one hand, right, like we understand that lots of bad things are done in the space of businesses. And I could give you examples where it seems pretty clear this is just some random individual whose behavior does not necessarily reflect that of the firm. There's some old cases of this where a firm gets convicted of essentially a theft crime because the employee committed the theft. But it was embezzlement. The employee stole from the company, so the company was simultaneously the perpetrator found guilty of the crime and also the only victim of the crime. So those strike many people, including me, as kind of instances of like, this is just like, right, this is bad basic reasoning about how the thing goes. I think the Knobe literature is helpful because it speaks to a broader phenomenon, which is our normative judgments are often driving as much as following from our empirical observations about a situation. So there's been lots of attention over the years to try to figure out well, how do we craft the right attribution rule? How do we know exactly when to attribute responsibility to the organization? And on the one hand, I'm sensitive to that kind of project. As a philosopher, I think that kind of project is fascinating. On the other hand, I do think that there's one kind of answer here is just to point out that we do very little of that at the level of individual criminal law. And we instead trust the jury to engage in this practice, which I think we're starting to appreciate is actually the jury engaging in some kind of normative deliberation and then working backwards to their conclusion. It turns out, right, that people have been able to do this for organizations just the same as individuals. In fact, if you look at the history of how this law developed, the big thorny question for judges at the time was, corporations have never been criminally responsible before. Can they now become criminally responsible? Of the courts that make that determination, particularly the state courts, most of them just immediately say, and we don't have to tell you anything more about this legal doctrine, because just present your case the way you present a case to an individual, and the jury will do the same work that juries always do. It's only much later that we start to try to figure out, do we need some kind of enshrined federal rule about when to attribute responsibility? So this is a long-winded way of saying, okay, I'm with you. And one thing that's nice about the way I learned to do philosophy is I went back and read just hundreds of old judicial opinions, and it's the same kind of like seat of the pants moral reasoning going on back then as they're trying to solve these things as we kind of might hope is going on now. I should say, seat of the pants moral reasoning was not a diss. That's like a compliment. But
yeah, no, I know. Steve has a great question that follows up on what you just described, which I think is, so Steve, go for it.
Hi. The question, I guess that I'm coming at it as a former building official, and the building permit example kind of caused me to think about, it's the corporate charter, right? So that's the device by which the public sector allows, under conditions, something to be done, and then there are the conditions, right? And so the question is, would, in a civil suit, or are there remedies in terms of pulling the corporate charter or amending the corporate charter, cabining the powers or the actions of the corporation inside the corporate charter, which would be would have the duration, you could either limit it in time or not, give it a perpetual scarlet letter. It seems to me that is really the social compact that allows corporations to exist. It seems like the core, the sort of the core instrument there. So if somebody, when I was a city building official, if somebody did an unpermitted addition, you need to demolish the addition and start over.
That's highly discretionary in most places, Steve. But yeah.
Well,
I mean, it really depends.
Yeah. I was the guy, right? And I said,
no, of course, right? No, and if you're the guy, but I'm just saying, that doesn't happen everywhere in a lot of places.
Right.
The more I just had a great example of in Cape Cod, there was a forest. It was undeveloped by the side of a road, and overnight, literally in the middle of the night, they brought in bulldozers and just razed it, and it was completely
that guy goes in California. That guy goes to jail.
Yeah, that's not what happens in Massachusetts, but that's but anyways, my point is some of it you can't raise an addition, this is a positive negative type of thing, but I get what you're saying. I'm curious to your point though, is how much discretion does the victim have in what they ask for in terms of remedy? As Steve suggests, can they come after the charter of the company, or is that the type of punishment dictated by statute?
Yeah, so a couple things. One, first, Steve, I like the idea of going back to the charter. I talked about the history, and I'm going to say a little bit more about it just because I think the history is interesting and instructive. But if you think about the old setup where the legislature would write your specific charter, a feature of that is that the legislature, at least in principle, had this oversight function where it would look at the business that you're going to go engage in, and it would decide whether or not it thought that was pro-social and productive. And then it would narrowly constrain what kinds of things your business could do to allow you to do all and only that behavior. This is back at a time, this actually predates the ultra vires doctrine, but it was long the case that a corporation could not do something that was outside the narrow purview of its charter. So what happens when we switch to a world where anybody can just go to their Secretary of State, fill out some paperwork and get a charter, is you lose that close attention to the behavior of the organization. So the organizations are suddenly writing their own charters to say, well, here's what this business is going to do. And we eventually get broader and broader language until we get to the status quo, which is our business will engage in all lawful enterprises. Turns out even that's like not that high a bar. I'm pretty sure Uber's original business model was just flagrant violations of the law. I might even like great laws, but like that was clearly in violation of the charter. Whatever. So, on this
Uber's model was breaking the law. The business model.
Oh
okay. Yeah, that's. I mean, I have to say they did follow. They had great follow through on that. Yeah.
Yeah.
Cancel culture has come for David Botts, though. Just everyone.
Oh man.
Like.
Oh my God! This is why I talked. It was so why it's so bad. David is a great guy. How could this happen to him?
This can happen to him. It can happen to anyone.
Oh
my God!
I'm back.
But yeah, really quickly, is can you go after the charter? Can you do things to change them? One thing that I'm talking about this as a criminal law person, but I do think it's worth remembering. Corporate law has much more flexibility than we have tended to take advantage of. Lots of the things we take for granted as just like a fixed feature of the business universe are not only not strictly speaking fixed, but like are relatively new, right? So when the Supreme Court's writing about the expansion of corporations in the 30s, one of the things they note is, well, only a third of the states have limited liability. This is just like not that long ago that the rules were really, really different. So I actually think there's lots of space where
insane.
Courts get involved. Yeah.
Wow.
Super interesting. David, you have a great question about the NRA, but hold on, go ahead, Scott.
No, I was just gonna repeat that shocking fact that you mentioned, Will, that a third only had limited liability in the 1930s. That is like a shocking. I'm sorry.
You know what else is crazy is that you needed your husband's permission to get a divorce in like 1930 and not 33%, but the majority of the states.
I know it was very bad for women, but it was really bad for corporations. Let's not forget that.
Yeah, exactly.
Yeah.
Only one of these two things can be people, Scott. According to the Supreme Court. Anyways, David, go ahead.
Thanks. This is super interesting. I'd be interested in your thoughts about if you'd want to try to deconstruct what AG Tisch from New York is doing to try to take apart and bring punishment to the NRA. And I think another portion of this kind of relates to the Texas two-step, where I think the NRA said, "Oh, you can't do it. We're bankrupt now. We're moving our articles of incorporation to another state, so you can't touch that." And you can. So, I'd be interested in your thoughts about that.
Yeah. So early on, Scott asked, why 1909? What was going on there? And I do think that one part I've written about this, but I think one thing that changed is the fact that when corporations developed this ability to sort of, jurisdiction hop, right, to move somewhere and change their incorporation and avoid certain sanctions, that's actually, I think, the moment where we start to see corporate law moving into the background as a primary source of regulating corporate activity. And instead, you start to see this move towards tort and criminal liability. Because it turns out, if you commit a crime here, it doesn't matter where you're incorporated, we can still reach you for your behavior. And I actually think we're seeing that like in real time with New York and the NRA. New York is sort of coming at this from multiple angles. They're coming at it from a very sort of, corporate, we're going to look at your founding documents and see if you're behaving, but they're also coming at it from this ex post enforcement kind of regime to say you can't just incorporate your way out of trouble. So when I say I think we need corporate criminal law, I think this is a move we made long ago, right? That we're going to have a particular kind of arrangement with organizations. And it also fits with a broader story about, to the extent that these organizations continue to gain legal rights and responsibilities, I think it's it's incumbent on the state to extend the costs of those beneficial legal statuses as well, which means criminal liability.
Okay, Itamar, you have a ton of questions. You cannot ask them all because we have 4 minutes left. You can ask your final one, which is the one about the state being uniquely equipped. And I think this is a great, very normative question and kind of is a little bit what I was asking before, but go ahead.
Yeah, sure. So let me read it off. So it's not obvious to me that like the state is uniquely equipped to inflict reputational damages to a company compared to like reporters and short sellers. Like it seems to me usually what happens is like a reporter will like investigate a company, they'll like find that it's done really bad things, and then or like there'll be short sellers that are invested in this too. And then like eventually they'll come up with enough evidence that the state will catch up and they'll impose a fine, and the short sellers will make a killing, and the reporter will like advance their career. So I'm curious as to like why you think the state would be like better at doing this than these private entities.
Yeah, good. So first off, I think you're exactly right that lots of the public consequences are coming before you get to the resolution of the criminal process. I do think it's not an either or as much as it's a both and. So I do think that there's reasons to think that even if these reputational sanctions or consequences happen prior to the conviction, that doesn't mean that there can't also be consequences following from conviction. I do think that particularly with the criminal law generally, the fact of criminal liability speaks loudly and it conveys something deeply important, right? So there's lots of people who think it is deeply important that Donald Trump be prosecuted for his behavior. And I don't think that any of those people think it's the case that anything about, like, we're going to learn anything new from that criminal process, right? They think that the state issuing that formal condemnation is in fact quite valuable. Now, to your point about, like, is the state good at this? When we say that the current setup of corporate criminal law is deeply ineffectual, more often than not, when a conviction is issued against an organization, stock price goes up. It goes up, not down. So
why?
The reason it goes up is, so it's twofold. One is the issue's off the table. And two, although you might assume that criminal fines for corporations are substantially larger than their civil fines, in fact, the opposite are true. I think it's something on the order of an 8-to-1. Yeah. So civil fines are on the order of 8 times larger than criminal fines.
Yeah. I mean, they can. I would assume that there's punitive damages, and those are just like probably just through the roof for a lot of these, right? I mean, or that they're brought through class action, which just like depending on the size of the class changes the size of the damages.
Yeah. So if there's follow-on civil litigation that can hang on the criminal conviction, then that's definitely a space where you get a larger possibility. By the way, that is a reason to take seriously corporate criminal liability, right? Even if the sanction itself is one thing, if it provides a basis for other people to recover their losses, that is like, that's all to the good.
But what if I just want like Jeff Bezos to like hang? Like what? God, because he just, no. I mean, what do we?
So
like no.
I should say 2 things. One is nothing that I've said.
God, that was a joke.
But we're gonna get thrown off a crowdcast if we say things like that.
I know. Yeah. For making death threats. Yeah. I let nothing against Jeff Bezos. It was a for instance. Also, our like Mike Pence is a lovely human being.
Yeah, I also just think that the worry. Actually, I realize it's 6:01. We should wrap it up. I was going to go off on another tangent, but that's not a great idea. Anyway, can I just ask where is your piece coming out?
We have the critical piece is coming out in the Journal of Corporation Law, And the
Okay.
branding piece, we've been talking about this summer. So we're wrapping the piece up in the next month or so, and then we'll be putting it out in the
I see. Is the,
Obviously.
upcoming cycle.
is the Journal of Corporate Law thing out yet?
It is, yeah. I can send
okay.
Oh, sorry. It's in the publishing now, but it's up on SSRN, so I can.
Okay. So this is okay. I just wanted, maybe we should drop the. I'll drop a link into the chat.
Oh yeah, I should be better at doing these things.
I thought that. Sorry, I'm
No.
I know which one you meant. I'm normally much better at this. This is what I'm good at. But I'm sorry that I missed this. I will. I'm sure you've seen a lot of it, but I will send you. I will send you some of the literature that I really like around this type of stuff. From when I used to do a bunch of it. Oh, perfect.
Yeah, I would love to. Yeah, that's the link.
And it was great to see you. And good luck getting home from Florida.
Thank you. And thanks everybody in the chat. I know I didn't sort of jump at you directly, but this was really delightful. So
it's pretty great. They're pretty awesome. They're like nice and it's very nice and very chatty and all nice and smart. Yeah, it's great. We will be back on Wednesday. It'll be Ben and Genevieve. I'm sure Ben will have many stories to tell about planting sunflowers at the Russian embassy in DC and them getting stomped on by like Russian thugs. I don't know, just some like crazy shit. But I kind of can't believe it really kind of goes to show you that they just like, it means nothing to them that like, sorry, I don't know if you guys saw this, but like Ben went this weekend and planted flowers around the Russian embassy, and some little girls like went and laid some sunflowers at like in front of the Russian embassy, and a guy driving into the Russian embassy a few minutes later got out of his car, stomped on the flowers and kicked them out of like the thing, and then drove his car into the Russian embassy. And I was like, wow, that's some bad reputation management. That is like really, although it is a little bit on brand, sadly, but like this is, but I do think that there's like reputation management doesn't really mean as much when you control most of the media that goes into your country. And like, yeah, so we're going to leave it there. We're not allowed to have fun anymore. But in lieu of fun,
we can't. Oh, I'm sorry. Were you asking?
No, I was lost. Go for it.
Okay, I would say we can't have fun anymore, but we can have corporate criminal liability without cancel culture, because that's really important. Because we don't want one. Yeah.
No, because cancel culture doesn't exist. Yeah.
That's also true. Anyway, thank you so much. Bye-bye. Thank you, Will. This was great.
Bye, Will.
It was very interesting.
Talk to you soon.